So, as we were discussing risk management and having insurance to be able to insulate the doctors, who we defined as deep pockets once they're making money in practice, there are ways other than insurance to mitigate the risk associated with having their assets attached in a lawsuit. One of them is to consider having a trust. But before I actually go to trust planning, most of you are going to at some point purchase a home or already have purchased a home. If that home is purchased between spouse, so you're married, and for those of you who are, Michigan law allows for you to have a special type of joint tenancy, and it's called tenancy by the entireties, and it is entirely driven by the marital agreement. Now, even though this is jointly held property, it cannot be attached to a judgment by judgment creditor. So your home, which for many of you will be, if not the primary, and it probably will be the primary asset in your early years, in your latter years, an IRA that rolls over from a retirement plan will be likely equal or exceed that. But your home is where you'll be, whether paying mortgage payments or not, your home is a important asset that you don't want attached in a lawsuit. So you'll hear us talk about the importance of titling. And that is, while that's true, and being able to shift titling in a way that protects the physician spouse, and yet there's sometimes both of you are physicians, so what do you do about that? I'll get to that in a minute. The idea is to start with assets that are can be titled simply, and your home is one of them.
Dan, a question that we get a lot when you're talking about titling your home is the use of LLCs for real property. Can you talk about that at all?
I can, but when I think of the LLC, Brad, it's not for one's home. When we talk about having limited liability companies, LLC being an acronym, it's a very useful device. Again, good Michigan law for property that's associated with your practice. Just as you may have a PLLC for the professional practice, you may have real estate. And many practices today are being consolidated, so you may have a holding company with multiple different pieces of real estate. And oftentimes the way that we fashion a discussion, which we always encourage you to then have to be checked with your own legal counsel, is to have a holding company with each office having their own LLC. And the reason that we see that as an optimal solution for real property in the professional context is because if we're sitting in office right now, this is my office, and if we have a fire, Red, it's going to destroy the furniture, the chairs, etc. But if I had fireproof walls, it wouldn't go beyond this office and destroy the whole 12th floor that we have. So we have the whole 12th floor, and there's multiple offices. If we want to protect the other offices from being burned, just like a holding company, we'd have multiple separate offices where each LLC may be taken down for some particular reason, but we protect the other offices in the process. So compartmentalizing offices that's a real property, having your home still titled jointly, is the beginning of good planning when it comes to insulating each particular entity, and what we are speaking of as property. There's also the question that we raise all the time is who is the breadwinner? And this not to be sexist, it could be the wife that is the breadwinner and the husband stay home. That's very common today.
Mm-hmm.
The question, it has nothing to do about gender. It has to do about the who's making the most money, who's the most likely candidate being at risk of a lawsuit.
Mm-hmm.
And to protect that person, we often recommend that monies, their savings, investments, be put in the trust, a revocable living trust of the non-professional spouse or the spouse that's making less money. Why? Because if, I'll use my wife as an example, for Priscilla, if I'm putting money in Priscilla's name, that money, if I'm sued, can't be attached. If we have a joint account, it can't.
Mm-hmm.
So since we have jointly held checking account, we use that as a pass-through just for pay bills. We don't accumulate money in that account.
Dan, you bring up a great point, though. Your wife is a physician.
She is.
And then you also have a nice business as well.
Correct.
So that can be applicable to people in your circumstance or physician couples.
Yes.
Following your same thought process there, how do physician couples or two highly compensated spouses, what mechanisms do they have to protect their assets?
One of the first things that I think is important to explore is, are you optimizing your qualified plans? Qualified plans are your 401k, your profit sharing, your 403b, your IRAs, anything that's qualified for a tax deferral. And the reason that that's important is that the more money that we are able to put into qualified plans, the greater protection we have. Now, there is some case law that suggests that in certain instances, an IRA can be invaded by a bankruptcy court judge. It's still rare, and there's only a couple cases. Vast majority of bankruptcy cases have never attached or invaded a individual retirement account, an IRA. But a 401k profit sharing, that's locked. There's no loss. So the law is very clear on that if you are funding a 403b account, a 401k account, a profit sharing account, that money is untouchable by a judgment creditor. That's good news for a physician, because you have the ability to structure your group practice retirement plan in any way you want. And if you're optimizing that which you can, and why are you? Because you're also trying to minimize income taxation.
Mm-hmm.
So being able to set up pre-tax income buckets is critical, but at the same time, they protect you.
Right. Yeah. One thing that is always interesting to me with that difference in types and levels of protection is the idea of ERISA. Can you talk briefly about the difference between what would be considered an ERISA plan, ERISA protected plan, and a non-ERISA protected qualified plan?
So ERISA is a body of law that was established by the Department of Labor. It provides oversight for all qualified plans. Again, I'm defining qualified as those plans that are employer-based, that we've just gone over, 403b, 401a, profit sharing, defined benefit, defined contribution, as well as those that are an individual retirement plan. So you can have a simple IRA, you can have a SEP IRA, simplified employee pension IRA, and in that case you're putting the maximum that you would in any retirement plan up to $56,000 this year. Those plans are different than non-qualified, and you, again, using the same vernacular, they're non-qualified plans when they don't qualify for a tax deferral, an individual account, a joint account, and an annuity as a non-qualified account. Even though there's tax deferral, it doesn't qualify for the type of tax deferral that is within a retirement plan. So as we've been discussing, we have qualified accounts and we have non-qualified accounts. And aside from the tax differences, the non-qualified accounts have the benefit of being liquid. So you can get at them You can go to the bank if you have a trust account. You can go to the bank if you have a joint account, and you can write checks off it. You, coming out of your fellowship and residency, have, as we talked about earlier, the need to effectively start your life, make purchases that you haven't made before, whether it be upgrading cars, whether it be your home, etc. You're going to need some cash. You're not going to put those strictly into long-term investment vehicles that you don't access until retirement. That at the very minimum is age 59 and a half, or you get penalized. So the idea of being able to plan for how much liquidity you will need versus how much we need to commit to long-term retirement plans that have the benefit of both the tax deferral and the protection, the asset protection that you'll want to seek, is really central to our initial planning for all of our physician clients.
Absolutely.
So I think that we're going to take another short break.
Yep. When we come back, we're going to talk a little bit more about just the basics of trusts and trust planning, because that, I think, will really tie this all together from an asset protection standpoint.